first case of the morning, number 20-60406, Garcia-Avila versus Garland, and Ms. Fry.
Your Honors, and may it please the Court, Melanie Fry on behalf of the petitioner Melanie Garcia-Avila. I'm joined today at counsel table and on the briefs by my colleague and my associate, Neyma Figueroa. We've reserved 5 minutes for rebuttal, and Ms. Figueroa will handle the rebuttal. I would note that today marks Ms. Figueroa's first oral argument.
Well, congratulations. You're arguing to somebody who never appeared in federal court, so you're ahead of me.
Your Honors, this is an appeal from the Board of Immigration Appeals' decision to remove Mr. Garcia-Avila from the United States. Congress has passed several statutes that allows petitioners like Mr. Garcia-Avila to petition to cancel removal. And one of these is what we call the regular way, the way that the majority of petitioners try to cancel removal. Under this statute, a petitioner has to demonstrate hardship in order to cancel removal, but not just any hardship, exceptional and extremely unusual hardship. It's a high standard, and not hardship to him, but exceptional, extremely unusual hardship to qualifying family members. There's a separate statute that Congress passed called the Violence Against Women Act. The acronym is VAWA, which basically seeks to protect the interests of battered spouses. For petitioners to which this statute applies, like Mr. Garcia-Avila, the hardship showing is much less. It's much more generous. It's easier to satisfy. And it's only extreme hardship. And the hardship to be considered is not just to qualifying family members, it's to the petitioner himself. In addition, the hardship is to be considered cumulatively, in the aggregate, both to the petitioner and to the family members. It is this VAWA standard that we are focused on today, that Mr. Garcia-Avila qualified under and petitioned for cancellation of removal under. Now, Mr. Garcia-Avila did apply for cancellation both ways, the regular way and the VAWA way. Under VAWA, the immigration judge was required to consider hardship to him, to Mr. Garcia-Avila himself. The immigration judge did not do that, nor did the Board of Immigration Appeals.
Did he put forth a case for hardship to himself?
He absolutely did, Your Honor. There was significant evidence that he would suffer hardship if removed, and that the hardship was to be suffered by him. This is detailed on pages 25 to 27 of our brief and includes things like he had little to no family ties in Mexico, record on appeal 317 to 318. He was left behind in the care of his grandmother as a toddler, and when his parents finally returned at the age of 15, he didn't even recognize them, meaning no family ties there in Mexico. He'd never had a family until meeting his wife and her parents here in the United States, meaning his only family is here. He came here as a teenager and lived here for 17 years, half of his life, record on appeal 140 to 41. Despite his limited educational opportunities, he had become the go-to guy for flooring installations, always presented himself as a family man, a man of God, and a humble businessman. There were letters of support in the record evidencing that he was a beloved member of his community in the United States. And importantly, the record contained evidence that he was returning to Michoacan, Mexico, which would mean return to a place that our State Department put on its do not travel list because of rampant crime. Record on appeal 317 to 318 and 29 to 30. In addition, the USCIS policy manual was referred to in the record regarding State Department travel warnings and explaining their significance to extreme hardship termination.
Is Mr. Garcia actually in Michoacan now?
Your Honor, the truth is I don't know. The record doesn't tell us. What I know from the record is that he did return there in 2020, that his 3 children, who were all United States citizens at the time of the briefing, they were 11, 7, and 3. They remained here, that Michoacan is a very remote area and it made communication difficult, and that the drug cartels, that is evidence.
When was the last time you were in contact with him?
I have never been in direct contact. His immigration lawyer in the proceedings below, I spoke to within the last week, and she assured me that she was able to contact him. The communication was difficult, but that she was able to speak.
So your belief is that he's still in Mexico?
I honestly don't
That
know.
would be very ironic, given current circumstances on the border.
I honestly don't know the answer.
Okay, just wondering.
I just have a, is that me? Am I echoing?
you.
Okay. Sorry. I just have a few threshold questions. Does the record reflect that your client affirmatively waived his right to appeal before the IJ? This was during a colloquy with the IJ where the IJ was saying, I'm going to grant you voluntary departure, but I want to know if you waived your right to appeal. Is that the case? And if so, what impact should that have on whether we should reach these issues in the appeal here?
It is correct that it was waived, Your Honor. In the record of the IJ hearing, she asks him, do you waive? And his attorney on his behalf says, are you going to allow involuntary departure? The IJ says yes, and the attorney says he waives. So that is in the record. It does not prohibit in any way a motion to reopen or motion to reconsider. It doesn't cut off your right to pursue those remedies. There was no direct appeal from the immigration judge's decision, but it didn't prevent him from filing a motion to reconsider and a motion to reopen. The procedural posture was therefore, he moves to petitions for cancellation of removal. The immigration judge has a hearing, makes a decision orally on the record. He waives appeal. He then files a motion to reconsider and motion to reopen. The motion to reopen was based on new evidence regarding the criminal proceedings.
Okay.
The IJ then issues a written decision denying those 2 motions, and that was appealed to the Board of Immigration Appeals, and then they issued a written decision affirming the immigration judge's decision not to reconsider and not to reopen. The reality is that there were 3 chances for the immigration judge and the BIA to get this right, to actually consider the hardship to Mr. Garcia-Avila. It's apparent from the oral transcript when the immigration judge is making her oral ruling that she did not consider hardship to Mr. Garcia-Avila individually. It's apparent in her written ruling that she didn't fix it, and she certainly had the opportunity to. She could have reconsidered and at that point detailed the evidence, and she did not. Finally, on the 3rd time, the BIA could have reviewed this and detailed the evidence and did not.
Okay, can I just ask one other sort of threshold question just to get your view? Does the record reflect that the IJ determined that your client was not eligible for cancellation based on a lack of good moral character? And if so, are you appealing that? And if you're not, does that impact, is that an independent basis for not granting the petition?
Based on the transcript and her oral ruling, she certainly was fixated on the probation revocation and what effect that might have on her ruling. There are several pages in the transcript talking about the criminal matter and the evidence that had come in the criminal proceedings. And there's a single sentence, just one, that says, I do not find extreme hardship to the children. And that's all that there is there. In the BIA opinion, it's much more clear that it was only hardship. They don't weigh in on good moral character.
I'm sorry, but I'm looking at the August 2019 immigration judge opinion, and she says, the respondent emphasizes that the court did not take into consideration the aggregate hardship of all the respondent's children as well as his own hardship. Then she says, a couple sentences later, the court duly considered the aggregate hardship to the respondent and his children. That would be caused by his removal and concluded his burden had not been met. What's wrong with that?
What's wrong with it is that it doesn't comply with this court's precedent with regard to what the immigration judge has to do. I'm referring specifically to the Ramos versus INS case. This was a 1983 case from the Fifth Circuit, as well as the Cabrera versus Sessions case from this court in 2018. Both of them set the standard for what has to be done. And it's so much more than the cursory and summary sentence that is present in the written opinion from the immigration judge. In Ramos, this court said, the decision must reflect that it has meaningfully addressed and reached a reasoned conclusion on the alien's specific assertions of hardship that are based on evidence. It is not our intention to require them a lengthy exegesis on immigration law or extended discussion of evidentiary minutiae. All we insist upon is a sufficient indication that they have a fair understanding of what the alien's various relevant contentions of hardship supported by the evidence actually are, and that they have meaningfully considered and evaluated each of these contentions, and that they provide a statement of the reasons why, in their opinion, these contentions do not, individually and in the aggregate, establish extreme hardship. In Cabrera, the court puts it this way.
What year was Cabrera?
Cabrera is 2018.
Okay.
Cabrera says, we do not require the BIA to specifically address every piece of evidence put before it, but it is error for the agency to fail to address key evidence. In other words, it's more than a cursory sentence. You know what, I considered that. I looked at it. Just trust me. In fact, this court has said in Ramos, it's insufficient to say that. This court says, to affirm on the theory that the board necessarily considered whatever the petitioner asserted would free the board of the obligation to articulate a reasoned basis for its decisions, eliminating any guarantee of rationality.
So you're not arguing your due process case here?
It's not simply a due process case. The statute itself has 4 factors for eligibility.
No, I'm talking about the probation revocation and the problems with the judge and all that. I thought that was a big issue.
It certainly is a big issue in the sense that all of the probation revocation has been undone. And not just that I think it was improper, but the state of Texas has now rolled all that back, acknowledged it was improper, reinstated probation, granted a writ of habeas corpus, and said, we're going to start over, everybody back to square one. It is a big deal in the sense that it is new evidence that was part of the motion to reopen. To your Honor's question, however, I do believe it will be an issue for the agency on remand. That remand here is required because of the procedural deficiency in the immigration judge and the Board of Immigration Appeals decisions in not analyzing the key evidence in support of an extreme hardship to the petitioner himself under VAWA, that legal error alone requires remand and reversal from this panel. That on remand, we believe that the board will consider this new evidence because circumstances have changed entirely. Your Honors, the obligation from Cabrera and Ramos is confirmed in other decisions of this court. Zamora Garcia would be another one that quotes from Ramos and talks about this idea of reviewing a determination procedurally to ensure the alien is receiving full and fair consideration of all circumstances that gave rise to their claims. If you look at both the oral recitation of the decision by the immigration judge, her written decision, and the BIA's written decision, they are divorced.
But aren't you really sort of, you're using the motion to reconsider, to re-argue the entire original proceeding, which he waived appeal from. Now, is it proper in immigration law to re-raise the issue that was vetted and decided by the immigration judge originally, and then appeal was waived? Because he certainly could have raised this business about the standards So just tell me where the regulations allow that. I'm sure I'm wrong, but you can explain it to me.
It is procedurally allowable to file a motion to reconsider in the way that he did.
Procedurally, yeah, but substantively, I don't understand.
I think my time is now.
Please answer, yeah.
The essence of the motion to reconsider is a procedural defect in the immigration judge's opinion. It is a proper vehicle to do that, not necessarily asking to reweigh all the factors, but instead saying it is procedurally deficient and the statute requires to be followed. Thank you.
All right, do you have time for rebuttal? Mr. Stanton? Now, do you need to look at that when we're talking?
You're close enough, I can agree with you. So, yeah, I can't read the back of her head, that's what I need the interpreting for. Yeah, but no, some courts in Kansas, way more, that was close enough, that's okay.
We're an intimate court.
Good luck.
Maybe to the court. About 6 weeks ago, my colleague Jessica Burns and I decided it would be mutually convenient to swap argument assignments. She took over an argument I had. In the Third Circuit, I took over this case which she briefed. And I'm sure that Ms. Burns, my Third Circuit brief, there are things she would have done differently. Happens all the time with lawyers. With respect to the brief that Ms. Burns put forth to this court, there's one big thing I would have done differently. It's a big one. I really hope the court can indulge me here. The Hernandez-Cordero decision, the 1987 decision that we cited on page 22 of our brief, and also our Rule 28J letter, that was an en banc decision from this court. And that makes a difference here. Ms. Fry argues that procedural error here is present because the agency's decision must reflect that it is meaningfully addressed and reach a reasoned conclusion on the, who's not citizen now, specific assertions of hardship that are based on the evidence. She cites Ramos versus INS, the 1983 decision, which in turn cited some Ninth Circuit decisions. Ramos, that same standard was followed later on by Zamora Garcia, and as well as a few other decisions cited in the petitioner's brief. Hernandez-Cordero announced a much more lenient standard of review when considering procedural error involving claims of extreme hardship. Hernandez-Cordero said so long as the agency gave any consideration to the hardship factors, and said, made a sentence that specifically considered the factors in the aggregate, then that satisfies this court's review, and the burden will be on petitioner to show, to firmly demonstrate error. So this meaningfully addressed and reasoned conclusion standard, which petitioner's case is entirely based on, is just not consistent with this court's en banc decision. 2 months after Hernandez-Cordero came out, this court had two decisions back-to-back. These are not cited in our brief. One was Lopez-Reyes versus INS, 1987 decision. Judge Jones, you were on that panel. The panel held that it was a very similar situation in this case, and the panel held even though the petition probably would have been granted under the old Ramos, the meaningful consideration standard, the petition had to be denied under the Hernandez-Cordero any consideration standard. This court held the exact same thing a few months later in a case called Vargas versus INS, again, 1987, shortly afterwards. And in case Ms. Fry is saying that this court pretends on rebuttal to claim that this court has never expressly held that the Ramos meaningful consideration standard has ever been abrogated. Yes, the court has indeed said that. Again, not cited in our brief, but a case called Palm Savannah, P-H-O-M, one word, Palm Savannah. It's the case number is 94-40208. It was on the summary calendar. Judge King, you were on that panel. Footnote 1 makes very clear the review standard articulated by Ramos did not survive Hernandez-Cordero, that the any consideration standard must be applied. One. So that's just not published, but it came out in 1994, which means it's a presidential decision. Rule 47.53, I love that rule. I mean, it's one of my favorite rules. And so it's precedent. I mean, no one knows about it, so I'm so happy to find those unpublished. Anyway, going on. Under that standard, the agency's decision here,
No, I want you to complete that thought, and then I wanted to ask about jurisdiction and our Trejo decision. It's very.
We under Trio, yeah. We said that in Rule 22.
I know that, and so I'm not going to belabor the point, but Trejo, this is a VAWA hardship case, is it not? VAWA, Violence Against Women Act. Is there no distinction in the VAWA determination of hardship and the discretion that the IJ has, distinction there, and in the statute involved in Trejo? I thought Trejo distinguished VAWA in terms of discretion, but I could be wrong about that, and you know it better than I do.
Well, I don't know the answer to that.
Okay.
We're talking about procedural irregularities here, whether or not the agency actually considered the appropriate factors. So I'm not sure if this court has ever defined extreme hardship under VAWA, but it has in Hernandez-Cordero under the old suspension of deportation. Both are extreme hardship. I have a hard time thinking the standard is different.
Okay, so just so I'm clear, the government agrees that there is jurisdiction here under our recent Trejo decision?
Yes.
Okay.
Yes. We do indeed agree with that. The Sixth Circuit done the same thing. So
Yeah.
we're conceding jurisdiction
Okay.
there as well. I would not be surprised if other ones as well. And so, but short answer is yes. And so, anyway, under the record here, we would respectfully submit that the agency's decision meets the any consideration standard under Hernandez-Cordero for the exact same reasons that Judge Jones said in the questionings to Ms. Fry. Here, the agency, the immigration judge in her August 2019 opinion said that she did indeed consider the hardships in the aggregate, both to the petitioner and to the children, and she also accurately articulated the substantive standards for extreme hardship. So, I mean, if you look at the transcript, I mean, the immigration judge began hearing the case sometime in the morning, whether it was 9 a.m. or 10 a.m., I'm not sure. They took a break around midday because the detention center was doing a detainee count, and they resumed proceedings around 1. Between 1 and about 3 o'clock, at least 3 times the immigration judge articulated both the regular and special cancellation rule standards. All those 3 were accurate now, and that's her closing argument. And so my guess is around 4 o'clock or so, she made a few comments to the effect that she intended to deny the applications, but that she was also wanted to know the petition regarding voluntary departure. She said she was going to retreat to go back to her chambers to prepare a formal oral decision. And when she came back, the petitioner informed that he wished to exercise the remedy of voluntary departure, and he was going to waive appeal. That authorized the immigration judge, it's almost the end of the day at this point, it's probably 5 o'clock, so that authorized the immigration judge to issue a summary denial, a summary order under the appropriate regulations. When someone accepts voluntary departure and says he's going to waive appeal, the immigration judge does not need to issue a formal oral decision. That's 8 CFR 1240.12 B as in boy. That will say in those circumstances you can issue a short summary decision. And so had a petitioner indicated that he wished to go forward with appeal, then I'm sure she would have issued a 15-page oral decision setting forth the standards, and saying, yes, I considered everything in the aggregate. So, she in her opinion, denied reconsideration. She did not say that she considered, explicitly stated on the record that she was weighing the hardships in the aggregate, but I'm sure she did so mentally. I mean, this is pretty basic stuff for immigration judges. They always have to consider cases in the aggregate, whether it's asylum, cancellation of removal, or adverse credibility. I mean, that's almost their bread and butter. It'd be pretty, I mean, I don't mean to be clear, we'd be pretty thin immigration judge not to know that they're supposed to consider everything in the aggregate. So
That leads me to follow up on something Judge Jones says. So the detainee waives appeal. So you're saying the judge doesn't give a more fulsome recitation of the reasons because she grants voluntary departure. Then there's a motion to reopen, motion to reconsider, and it's appropriate. And I'm just asking an informational question. It's appropriate then to go and sort of re-argue the grounds on which appeal had been waived via a motion to reopen?
I mean, it's a very unusual situation. I've never seen it happen before. I mean, and my personal guess is that this particular immigration judge is not going to say anything. She's going to say, "I intend to deny your application. Do you wish to take appeal?" And that's probably what she's going to be doing from now on. She submitted a few comments, and so. But with respect to your question, I was imagining that, as Ms. Fry said, it's certainly appropriate to argue procedural error. So, but as far as substantively, I don't think the substantive merits of the hardship are before this court.
Okay.
They were never really before the agency. So, I mean, the agency certainly never reached the. Well, this the board didn't. At least the board didn't reach the substantive grounds for extreme hardship. So, I mean, to the effect that, I mean, if you want my opinion, I don't think he qualified for extreme hardship. And in closing argument, petitioner, counsel only cited two things. He cited his difficult childhood and crime in Mexico. I mean, I don't mean to sound insensitive.
It would seem to open the door. If that were the standard, that would seem to open the door to lots of extreme hardship claims.
Again, it's not before the court, but
Right.
if you ask me, I think so. I mean, but it's not my opinion. It's the agency's decision. They did not actually. At least the board didn't get to that. What the board did was it affirmed the immigration judge's denial of reconsideration, and we respectfully submit that's not an abuse of discretion, which is the appropriate standard here, and it certainly does not reach the level of procedural error required by this court's en banc decision in Hernandez Cordero. And so, and again, I mean, just because, and I'll also say, just because the agency says that's considered all the evidence in the aggregate, that doesn't mean that the inquiry is completely over. It is still possible for the petitioner to affirmatively show error, if the agency didn't happen here, but if the agency decided that we considered everything in the aggregate, but by the way, we also think that one of the children does not qualify as a qualifying relative for a reason that's wrong, like it's an adopted kid or it's a kid who's born from an extramarital affair. I'm not going to consider that. That would be pretty, and it's wrong, which it is. And so if there's some indication in the opinion that the agency did not, in fact, consider the aggregate hardships to all the qualifying relatives, then this court will be allowed to disregard the statement that it considered all the evidence in the aggregate. I would acknowledge that it's very difficult for a petitioner here to meet that standard because we don't have a written opinion from the immigration judge setting forth her findings. But again, whose fault is that? I mean, he was the one who waived the appeal. He went forward with the appeal. We have a fulsome opinion, and maybe there'd be here, maybe there'd be not. But instead, he waived the appeal, filed a motion for reconsideration. The immigration judge said, yes, I did consider everything in the aggregate. And under Hernandez Cordero, as well as the case that followed Hernandez Cordero, I mean, then we submit that's enough. Again, I apologize. These cases are not cited in the government's brief. If the court wishes, I'm more than happy to submit a Rule 28J letter when I get back to Washington.
That would be helpful.
Yeah, I promise I will do that. And
Thank
so,
you.
and if Mr. Fry wishes to respond, I absolutely have no objection whatsoever to that. So, and just on the standard review, like, and a lot of cases, I hope you read it correctly, but I understand it'll be better if you had it on paper. And so,
Since there's a lot in the
yes.
briefing about the DWI and the cocaine tests and all, would you please explain what's going on with those issues?
Well, the board didn't address them, so, I mean, the board decided, it was going to affirm the immigration judge strictly on the hardship grounds. So, I mean, so as far as the government is concerned, the issue of his good moral character, his criminal histories, the cocaine, the DUI is just not before the court right now. So, if the court were to grant a petition for whatever reason, and for the reasons I've discussed, and Ms. Burns said it brief, we don't think the court should. The appropriate remedy would be to remand for the board, and its instructions to the board to address the good moral character and finding the cocaine, the DUI, and all that. But for now, I mean, I'm limited to what the board actually did. And so, again, hardship is an element for both regular and special cancellation. So, I mean, he could be a deacon in his church with 100 letters of recommendation from fellow churchgoers saying he's the nicest guy in the entire world. But if he didn't show hardship, he won't be able to get the benefit. Right. So, all right. Okay. That's kind of about done. Any questions that I may have? Okay.
No, sir. Thank you.
I'll just on the briefs.
All right, thank you. Ms. Fry. I'm sorry, Figueroa.
I'd like to touch on 3 things that you've heard from the government. The first being what the applicable standard procedurally that the agency must meet. The second is issue that everyone seems to be interested in as to the effect of our client waiving his right to appeal. And third, what it is that the record does in fact reflect that. And so turning to the first issue, this case that Mr. Stanton has handed to us, the Palm Savannah matter, which he represented to you to be an en banc decision, is
No,
actually...
he said Hernandez Cordero was en banc. It preceded that one.
I stand corrected. You're
That's
correct.
okay, thank you.
And I you'll get to respond to the government's 28J letter. And I know it's kind of disorienting to have, well, there's these new cases now, but you'll get to respond to that.
And so, do you want me to skip it?
No, I want you to tell us what you want to tell us, but you'll get to respond in writing to the
So
government.
in Cordero, the 2018 published decision that Ms. Fry alluded to earlier, this court cites to a 1996 also published decision of Edelyn. I think that's how you say it. And in that case, it's a Sudanese person who is seeking asylum, and part of his case is that he's got a well-founded fear of future persecution if he returns to Sudan. Part of his evidence before the court is that since he's been in the United States, his brother and mother have been questioned as to his whereabouts. And as to that piece of evidence, what the court says, the Fifth Circuit Court says, it cites to the paragraph that the BIA puts forth where it doesn't talk at all about this evidence. And so the court says the fact that the unidentified people were asking questions about the respondent at his former workplace doesn't show that the government may now be inclined to prosecute him, so on and so forth. This paragraph constitutes the BIA's entire recitation as to this piece of key evidence. And so even if we accept that the standard is just any consideration, if you look at the record here, there is no consideration whatsoever. In fact, there isn't even a recitation of the correct standard, right? The correct standard under VAWA is that our client, hardship to himself and his children is there. At the end of the hearing, when she is announcing her decision, she simply says, and I considered the hardship to your children, and I find that that's not met.
Let me ask you a question. I take it that Mr. Garcia-Avila and his wife are still married.
Yes, Your Honor, that is our understanding.
So he wants asylum, or whatever you call it, under VAWA for having an abusive spouse who he prefers to be with.
Yes, Your Honor, and if you look, the evidence in the record also showed that their relationship has come a long way. He was subject to abuse, physical abuse by his spouse while they were married, but since then, she's been a lot better, and it was his testimony that he intended to remain with his spouse and children.
Well, that does raise a bit of a ethical question in my mind about whether this is a legitimate basis for us to consider his argument.
And Your Honor, respectfully, I think that that would probably be a consideration for the board on remand as to whether, I think that would go to the discretionary factor of whether cancellation of removal is proper, right? But it doesn't free the agency from its obligation to, at the very least, recite the correct standard, and it hasn't even done that. The other issue that was raised is whether our client's waiver of appeal relieves the board or relieves the IJ from getting a reasoned opinion. And in the motion to reopen, we clearly pointed out what we were complaining about. We said, hey, we think you conflated the two hardship standards and you didn't consider hardship to Mr. Garcia-Avila. And instead of coming forth and setting out, hey, I did, I noticed that you testified to the fact that you were abandoned at age 2 and that Mexico is rampant with crime and that you have no family ties there, but I still found that you didn't meet the requisite hardship standard, she simply gives the self-serving conclusory statement of, I did, and you're just going to have to take my word for it that I did in fact consider all of the evidence and that you didn't meet the standard. And if you look at the BIA decision once again simply says he was given an opportunity to detail the evidence of hardship to his children. So at 3 times, no one, and Your Honor, I see that I'm out of time, may I finish the sentence?
Yep.
At no point in any of the 3 key documents in the record do you see any mention of hardship to Mr. Garcia-Avila. And for that reason, even if you consider any consideration standard, we would ask that you pull that remand for a new hearing as proper.
Thank you.
All right, thank you very much. That was a challenging argument. You spoke well. Thank you, Mrs. McCall.